First is Farhane v. United States out of the Second Circuit en banc on October 31st, technically, but it's a November case because that immigration review episode published in November. And, the Ninth Circuit's the only circuit where when they do en banc, it's not the full court. Every other circuit, to my knowledge, is literally every judge on the court. So this is the full Second Circuit overruling Farhane v. United States, which I had done like 100 episodes prior, which is always amusing to me. And I try to go back and see, what did I say the first time? Did I call it that this is not? And I did. In my defense, I did on Farhane. And when the first Farhane, I'm like, this is weird, guys. What are you doing? And it's about denaturalization and ineffective assistance of counsel in Padilla. And the full Second Circuit, with a dissent, but the full Second Circuit said essentially that if criminal counsel doesn't advise of the immigration consequences of a plea, then there is an ineffective assistance of counsel claim lying there such that you can get that conviction vacated before or alongside the U.S. government's attempt to denaturalize. That's already the case when it's removal proceedings, right? If an LPR accepts a plea, then, and they weren't advised of the immigration consequences, they were affirmatively misadvised. That's a Padilla v. Kentucky, Fifth Amendment violation, Sixth Amendment violation, I'm sorry, that then has effects because they were subject to removal. But in the DNAT's context, what happens when the U.S. citizen takes the plea, but then it subjects him to denaturalization? That's a very difficult and interesting fact pattern, but it's something we're going to be seeing a lot more under Trump too, with, Stephen Miller's already bragging about their denaturalization task force like they did last time. And they always focus on these conspiracies, these conspiracy convictions, because those are the easiest types of things to denaturalize someone for, because the conspiracy always begins before they became a U.S. citizen and ends after they became a U.S. citizen. And in their plea deal, they admit to the years of conspiracy. So they are essentially admitting that they were committing criminal conduct while they were an LPR, which they, of course, did not disclose in their naturalization application, thereby making a pretty easy case to denaturalize them. Because, the N-400 and the oath ceremony asks, have you ever committed criminal activity they haven't been arrested for? And here they are pleading to literally doing just that. In this case, the guy was giving money to the Mujahideen in Afghanistan and Chechnya. And they got him for money laundering. And then it just so happens to be to fundamentalist Islamic fighters as well. And he pled guilty to it. And then immediately tried to get it vacated. I was never advised. Because he became a citizen. They tried to denaturalize him for it. And it's not just affirmative misadvice from the Second Circuit. Quote, silence on the subject breached the Sixth Amendment duty to advise, end quote. Criminal attorneys with a criminal case for a citizen, I think a lot of them aren't going to be advising of the immigration consequences. They're not going to be thinking that this could subject them to denaturalization. So this might be more prevalent than one would think. And it's really something to know for the coming Trump administration, again, when they're going to be beefing up this alleged denaturalization task force. Quote, to provide effective representation, counsel must advise her client as to the paired set of serious adverse immigration consequences by at least flagging the risk. As many have observed, the risk of banishment may weigh more heavily in a criminal defendant's assessment of his options than any particular sentence of incarceration, end quote. So even though he admitted it in the plea agreement, it looks like it's all going to probably be vacated. And, the U.S. government can seek to denaturalize him again. You don't need a conviction, but they're not going to have very good evidence, right, if he doesn't have the conviction for conspiracy. And in denaturalization, it is the U.S. government's burden. And it's a heavy burden at that.